So the first question asks, what is meant by the sources of international law, and why, according to Mitchell and Beard, is finding the sources a more complicated process when compared to the domestic legal system? In general, sources of law are a means of identifying what a legal rule is and how it was created. More specifically, material sources refer to the material used to identify a legal rule, and formal sources refer to the method by which a rule became law. At international law, there is often no clear distinction between these two sources. Sources of international law are not physical sources like books or databases that contain the law, but rather the ways in which rules of international law can emerge. Rules of international law can emerge in different ways and can be different from domestic sources, such as customary international law, or can be similar, such as treaties and legislation. Mitchell and Beard explain that finding sources of international law is a more complicated process in comparison with domestic law, because in an international legal system, there is no universal legislator or judiciary that can create or interpret laws that bind all states. Furthermore, while there are many international organizations, no hierarchy exists to govern such bodies. On the other hand, it is relatively straightforward to determine the law in domestic legal systems because laws are typically determined by previous court decisions, such as in the common law, or codified in statutes and legislation, such as in the civil law. Question 2 asks, what are the sources of public international law? Are these also the sources of private international law? And what happens if there's a conflict between different sources of public international law? Sources of public international law are set out in Article 38, Section 1 of the Statute of the International Court of Justice. Article 38, Section 1 states, "The court, whose function is to decide in accordance with international law such disputes as are submitted to it, shall apply a. International conventions, whether general or particular, establishing rules expressly recognized by the contesting states, b. International custom, as evidence of a general practice accepted as law, also known as customary international law, c. The general principles of law recognized by civilized nations, meaning states acting in good faith, d. Subject to the provisions of Article 59, judicial decisions and the teachings of the most highly qualified publicists of the various nations as subsidiary means for the determination of rules of law." Although there is no official hierarchy of sources, Article 38 1d states that judicial decisions and academics are subsidiary to conventions, customs, and general principles of law. As such, the sources outlined in Article 38 1a through c are considered to be primary sources. In a situation where there's a conflict between different sources of public international law, there are two general rules to help determine which source of law should be applicable. Lex posterior derogat legi priori provides that the latter rule prevails, meaning the most recent, and lex specialis derogat legi generali provides that the more specific rule should prevail over a general one. It is important to note that these sources are not the sources of private international law. Sources of private international law come from domestic legal systems of the states involved. When determining which laws are to be applied, parties and courts will consider factors such as jurisdiction and subsequently the choice of law.